counterclaim. So a counterclaim is any claim which a defending party may have against an opposing party. A counterclaim partakes of the nature of a complaint and/or a cause of action against the plaintiff in a case. Only this time, it is the original defendant who becomes the plaintiff. Let's illustrate. So, the plaintiff files a complaint against the defendant. Now, the defendant files an answer. Usually, a counterclaim is included in the answer. Now, let us talk about compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court both as to the amount and the nature thereof, except that in original action before the regional trial court, the counterclaim may be considered compulsory regardless of the amount. Thus, a counterclaim cannot be the subject of a separate action, but it should instead be asserted in the same suit involving the same transaction or occurrence which give rise to it. So take note, this is a compulsory counterclaim. Now, a counterclaim before the MTC must be within the jurisdiction of the MTC, both as to the amount and nature thereof. On the other hand, in an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. Let's illustrate a compulsory counterclaim. So, let's say an action publiciana filed with the RTC where the value of the land is 1 million pesos and defendant claims for reimbursement of 50,000, the reimbursement should be considered as a compulsory counterclaim because the original action was filed with the RTC. However, the nature of the action is always material such that unlawful detainer cannot be set up in the RTC. Okay, if a counterclaim is filed in the MTC in excess of its jurisdictional amount, the excess would be considered as waived. Okay, compulsory counterclaim. What are the requisites of a compulsory counterclaim? Considering Section 4 of Rule 9 of the Rules of Court, a counterclaim is compulsory if, first, it arises out of or is necessarily connected with the transaction or occurrence which is the subject matter of the opposing party's claim. Second, it does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. And finally, the court has jurisdiction to entertain the claim. How can we determine if the counterclaim is compulsory? So there are tests to determine if a claim or if a counterclaim is compulsory. So in Valencia versus Court of Appeals, the Supreme Court capsulized the criteria or tests that may be used in determining whether a counterclaim is compulsory or permissive, summarized as follows. Number 1, are the issues of fact and law raised by the claim and counterclaim largely the same? Number 2, would res judicata bar a subsequent suit on defendant's claim absent the compulsory counterclaim rule? Number 3, will substantially the same evidence support or refute plaintiff's claim as well as defendant's counterclaim? And number 4, is there any logical relation between the claim and the counterclaim? Affirmative answers to the above queries indicate the existence of a compulsory counterclaim. Let's take a look at compulsory counterclaim for damages. Usually, claims for damages allegedly suffered as a result of the filing of the complaint are compulsory. A counterclaim purely for damages and attorney's fees by reason of the unfounded suit filed by the other party or the plaintiff has long been settled as falling under the classification of compulsory counterclaim and it must be pleaded in the same action, otherwise it is barred. Okay? In Lafarge Cement versus Continental Cement, citing Chu Po et al. Versus Honorable Bautista, the Supreme Court held that counterclaims seeking moral, actual, and exemplary damages and attorney's fees against the plaintiff on account of their malicious and unfounded complaint was considered compulsory. Another test applied in the case of Quintanilla versus Court of Appeals is the compelling test of compulsoriness, which requires a logical relationship between the claim and the counterclaim. That is, where conducting separate trials of the respective claims of the parties would entail a substantial duplication of effort and time, as where they involve many of the same factual and/or legal issues. The phrase logical relationship is given meaning by the purpose of the rule which it was designed to implement. Thus, a counterclaim is logically related to the opposing party's claim where separate trials of each of their respective claims would involve a substantial duplication of effort and time by the parties and the courts. Where multiple claims involve many of the same factual issues, or where they are offshoots of the same basic controversy between the parties, fairness and considerations of convenience and of economy require that the counterclaimant be permitted to maintain his cause of action. Here is an example of a compulsory counterclaim in the case of Spouses Meliton versus Court of Appeals, GR number 101883, December 11, 1992. Private respondent's complaint was for rescission of the contract of lease due to petitioner Lydia Meliton's breach of her obligations under the said contract. On the other hand, petitioner's counterclaims were for damages for unlawful demolition of the improvements she introduced pursuant to her leasehold occupancy of the premises, as well as for the filing of that civil suit which is contended to be clearly unfounded. The Supreme Court held that both the claims of petitioners and private respondent arose from the same contract of lease. The rights and obligations of the parties, as well as their potential liability for damages, emanated from the same contractual relation. Petitioners' right to claim damages for the unlawful demolition of the improvements they introduced on the land was based on the right of possession under the contract of lease, which is precisely the very same contract sought to be rescinded by private respondent in her complaint. The two actions are but the consequences of the reciprocal obligations imposed by law upon and assumed by the parties under their aforesaid lease contract. That contract of lease pleaded by private respondent constitutes the foundation and basis relied on by both parties for recovery of their respective claims. Okay, the Supreme Court went on further and explained that the relationship between petitioner's counterclaims and private respondent's complaint is substantially the same as that which exists between a complaint for recovery of land by the owner and the claim for improvements introduced therein by the possessor. As the Supreme Court ruled, in actions for ejectment or for recovery of possession of real property, it is well settled that the defendant's claims for the value of the improvements on the property or necessary expenses for its preservation are required to be interposed in the same action as compulsory counterclaims. In such cases, it is the refusal of the defendant to vacate or surrender possession of the premises that serves as the vital link in the chain of facts and events and which constitutes the transaction upon which the plaintiff bases his causes of action. It is likewise an important part of the transaction constituting the subject matter of the counterclaim of the defendant for the value of the improvements or the necessary expenses incurred for the preservation of the property. They are offshoots of the same basic controversy between the parties, that is, the right of either to the possession of the property. Now, why is it important to know if a counterclaim is compulsory? Because, unlike permissive counterclaims, compulsory counterclaims should be set up in the same action. Otherwise, they would be barred forever. The rules provide that a compulsory counterclaim or a cross-claim not set up shall be barred. Now, question. Is there a need to file an answer to a compulsory counterclaim such that if the opposing party fails to file an answer, he may be declared in default? A plaintiff who fails or chooses not to answer a compulsory counterclaim may not be declared in default, principally because the issues raised in the counterclaim are deemed automatically joined by the allegations of the complaint. Please take note that a compulsory counterclaim is incompatible with a motion to dismiss filed by the defendant. A compulsory counterclaim is auxiliary to the proceeding in the original suit and derives its jurisdictional support therefrom. A counterclaim presupposes the existence of a claim against the party filing the counterclaim. Hence, where there is no claim against the counterclaimant, the counterclaim is improper and it must be dismissed, more so where the complaint is dismissed at the instance of the counterclaimant. In other words, if the dismissal of the main action results in the dismissal of the counterclaim already filed, it stands to reason that the filing of a motion to dismiss the complaint is an implied waiver of the compulsory counterclaim because the grant of the motion ultimately results in the dismissal of the counterclaim. Thus, the filing of a motion to dismiss and the setting up of a compulsory counterclaim are incompatible remedies. In the event that a defending party has a ground for dismissal and a compulsory counterclaim at the same time, he must choose only one remedy. If he decides to file a motion to dismiss, he will lose his compulsory counterclaim. But if he opts to set up his counterclaim or compulsory counterclaim, he may still plead his ground for dismissal as an affirmative defense in his answer. The latter option is obviously more favorable to the defendant. So what is the rule on compulsory counterclaim again? Unlike permissive counterclaims, compulsory counterclaims should be set up in the same action, otherwise they would be barred forever. Okay, compulsory counterclaim not set up in the answer is deemed barred, but there are exceptions. If it is a counterclaim which either matured or was acquired by a party after serving his answer, in this case, it may be pleaded by filing a supplemental answer or pleading before judgment with the permission of the court. Next, when a pleader fails to set up a counterclaim through oversight, inadvertence, excusable negligence, or when justice requires, he may, by leave of court, set up the counterclaim by amendment of the pleadings before judgment. Now let's talk about permissive counterclaim. When any of the elements of a compulsory counterclaim is absent, then it is considered a permissive counterclaim. A counterclaim is permissive if it does not arise out of or is not necessarily connected with the subject matter of the opposing party's claim. It is essentially an independent claim that may be filed separately in another case. The evidence required to prove a permissive counterclaim differs from that needed to establish the plaintiff's demands. The recovery of plaintiff's claims is not contingent or dependent upon establishing defendant's counterclaim, such that conducting separate trials will not result in the substantial duplication of the time and effort of the court and the parties. One would search the records in vain for a logical connection between the parties' claims. The determination of the nature of a counterclaim is relevant for the purpose of compliance with the requirements of initiatory pleadings. In order for the court to acquire jurisdiction, permissive counterclaims require payment of docket fees, while compulsory counterclaims do not. An answer must be filed, otherwise the plaintiff may be declared in default. In the case of Sandejas versus Spouses in Ignacio, the Supreme Court held that in order for the trial court to acquire jurisdiction over her permissive counterclaim, Rosita is bound to pay the prescribed docket fees. Since it is not disputed that Rosita never paid the docket and filing fees, the RTC did not acquire jurisdiction over her permissive counterclaim. Nonetheless, the trial court ruled on the merits of Rosita's permissive counterclaim by dismissing the same on the ground that she failed to establish that there is a sharing agreement between her and Arturo with respect to the proceeds of the sale of the subject Moraita property, and that the amount of 3 million pesos represented by the check which Rosita and Alice encashed formed part of the proceeds of the said sales. The court ruled that it is settled that any decision rendered without jurisdiction is a total nullity and may be struck down at any time, even on appeal before the court. In the present case, considering that the trial court did not acquire jurisdiction over the permissive counterclaim of Rosita, any proceeding taken upon by the trial court and any ruling or judgment rendered in relation to such counterclaim is considered null and void. In effect, Rosita may file a separate action against Arturo for recovery of a sum of money. Another case, GSIS versus heirs of Caballero. The Supreme Court held that the issue in the main action, that is, the nullity or validity of the bid award, deed of absolute sale, and TCT, is entirely different from the issue in the counterclaim, that is, whether petitioner is entitled to receive the rent payments over the subject property when petitioner became the owner of the subject property by virtue of the consolidation of ownership of the property in its favor. The rule in permissive counterclaims is that for the trial court to acquire jurisdiction, the counterclaimant is bound to pay the prescribed docket fees. This, petitioner did not do, because it asserted that its claim for the collection of rental payments was a compulsory counterclaim. Since petitioner failed to pay the docket fees, the RTC did not acquire jurisdiction over its permissive counterclaim. The judgment rendered by the RTC, insofar as it ordered Fernando to pay petitioner the rentals which he collected from CMTC, is considered null and void. Any decision rendered without jurisdiction is a total nullity and may be struck down at any time, even on appeal before the Supreme Court. Let us distinguish between a compulsory counterclaim and a permissive counterclaim. Okay, so a compulsory counterclaim arises out of or is necessarily connected with a transaction or occurrence that is the subject matter of the opposing party's claim, whereas a permissive counterclaim does not arise out of, nor is it necessarily connected with the subject matter of the opposing party's claim. A compulsory counterclaim does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. On the other hand, permissive counterclaim may require for its adjudication the presence of third parties over whom the court cannot acquire jurisdiction. Compulsory counterclaim is barred if not set up in the action, while permissive counterclaim is not barred even if it is not set up in the action. Further, a compulsory counterclaim is not an initiatory pleading, whereas a permissive counterclaim is an initiatory pleading. If it is a compulsory counterclaim, the lack of a certificate of non-forum shopping is immaterial, since it is not required. If it is a permissive counterclaim, the lack of a certificate of non-forum shopping is fatal, because a certificate of non-forum shopping is required in permissive counterclaims. As to the payment of docket fees, it was explained in the case of Villanueva-Ong versus Enrile, GR number 212904, a 2017 decision of the court, that neither should her counterclaims be dismissed pursuant to the court's ruling in Korea Technologies versus Honorable Lerma, which held that effective August 16, 2004, under Section 7, Rule 141 as amended by AM number 04-2-04-SC, docket fees are now required to be paid in compulsory counterclaim or cross-claims. Note must be taken of OCA Circular Number 96-2009 entitled Docket Fees for Compulsory Counterclaims, dated August 13, 2009, where it was clarified that the rule on imposition of filing fees on compulsory counterclaims has been suspended. Such suspension remains in force up to this day, according to the Supreme Court in that 2017 decision. So, in short, in compulsory counterclaim, payment of docket fees is not required, whereas in permissive counterclaim, payment of docket fees is required. How about the filing of an answer? In compulsory counterclaim, the filing of an answer to a compulsory counterclaim is not required, because if it merely reiterates special defenses, they are deemed controverted even without an answer. Failure to file an answer to a compulsory counterclaim may not be a cause for declaration of default. However, a permissive counterclaim must be answered. Otherwise, the party may be declared in default as to the counterclaim. Okay, question. Is certificate of non-forum shopping required in the filing of a counterclaim? The pertinent provisions of Administrative Circular Number 04-94 provide that the plaintiff, petitioner, applicant, or principal party seeking relief in the complaint, petition, application, or other initiatory pleading shall certify or shall file a certificate of non-forum shopping. The complaint and other initiatory pleadings referred to and subject of this circular are the original, civil, complaint, counterclaim, cross-claim, third or fourth, etc. party complaint, or complaint and intervention, petition, or application wherein a party asserts his claim for relief. So take note that in Administrative Circular Number 04-94 requiring the filing of a certificate of non-forum shopping, it mentions counterclaim without distinguishing between a permissive or a compulsory counterclaim. But the Supreme Court held in one case that it should not be too difficult, the foregoing rationale of the circular aptly taken to sustain the view that the circular in question has not, in fact, been contemplated to include a kind of claim which by its very nature, as being auxiliary to the proceeding in the suit, and as deriving its substantive and jurisdictional support therefrom, can only be appropriately pleaded in the answer and not remain outstanding for independent resolution except by the court where the main case pends. Prescinding from the foregoing, the proviso in the second paragraph of Section 5, Rule 8 of the 1997 Rules of Civil Procedure, that is, the violation of the anti-forum shopping rule, shall not be curable by mere amendment, but shall be cause for the dismissal of the case without prejudice, being predicated on the applicability of the need for a certification against forum shopping, obviously does not include a claim which cannot be independently set up, or it does not include a compulsory counterclaim. A compulsory counterclaim cannot be independently set up. Okay, is that clear? Now, as to the payment of docket fees and the filing of a counterclaim, is this required? In one case, the Supreme Court held that there is no need for a petitioner to pay docket fees for her compulsory counterclaim. On the other hand, in order for the trial court to acquire jurisdiction over her permissive counterclaim, petitioner is bound to pay the prescribed docket fees. The rule on the payment of filing fees has been laid down by the court in the case of Sun Insurance Office versus Honorable Maximiano Asuncion. 1. It is not simply the filing of the complaint or appropriate initiatory pleading, but the payment of the prescribed docket fee that vests a trial court with jurisdiction over the subject matter or nature of the action. Where the filing of the initiatory pleading is not accompanied by payment of the docket fee, the court may allow payment of the fee within a reasonable time, but in no case beyond the applicable prescriptive or reglementary period. Second, the same rule applies to permissive counterclaims, third-party claims, and similar pleadings, which shall not be considered filed until and unless the filing fee prescribed therefor is paid. The court may allow payment of said fee within a reasonable time, but also in no case beyond its applicable, prescriptive, or reglementary period. Now, should an answer to a counterclaim be filed? The answer can be tricky because before the court acquires jurisdiction over the permissive counterclaim, let's say the docket fees are not yet paid, then the answer is not necessary because the permissive counterclaim is not within the court's jurisdiction, or the court has not acquired jurisdiction over the permissive counterclaim. If there is no answer, there may be no declaration of default. But if the counterclaimant paid the prescribed docket fees, then the court acquired jurisdiction over the permissive counterclaim, then the opposing party fails to file an answer to the permissive counterclaim, the opposing party may be declared in default. And in that sense, an answer to a permissive counterclaim must be filed. Meanwhile, the compulsory counterclaim for damages based on the filing of an allegedly unfounded and malicious suit need not be answered since it is inseparable from the claims of the plaintiff. If the plaintiff were to answer the compulsory counterclaim of the defendant, it would merely result in the former pleading the same facts raised in its complaint. So what happens to the counterclaim if the complaint is dismissed? You have to distinguish if the dismissal is initiated by the defendant or initiated by the plaintiff. Because as we've discussed earlier, a motion to dismiss filed by the defendant cannot coexist with a compulsory counterclaim. Okay? Because a compulsory counterclaim is auxiliary to the main action or to the complaint, such that the dismissal of the complaint also results in the dismissal of the compulsory counterclaim. Okay, so if the dismissal of the complaint is initiated by the defendant, the counterclaim already filed is also dismissed. If it is a compulsory counterclaim, it is barred. If it is a permissive counterclaim, it can be independently filed. On the other hand, if the dismissal is initiated by the plaintiff, the dismissal is without prejudice to the prosecution of the counterclaim. See Rule 17 on dismissal of actions on the effects of the dismissal of actions upon a counterclaim.